The recording is on.
Okay, I'm going to go ahead and call this meeting to order. This is the City of San Diego Commission on Police Practices ad hoc committee on operating procedures. And today's date is February the 29th, 2024.
28.
28.
What? Oh, today's the 28th. See, I told you I was confused of what day it was, so the 28th. And so we have present our Chief Investigating Officer, Olga Golub, and we have Commissioner Clovis Honore, and myself, I'm the first vice chair of the commission. I'm Doug Case, and we're going to proceed through the rest of the operating procedure on investigations. And if Olga could remind us how far we got last time.
Yep, so I just started sharing my screen also, so let me know if you see it.
Okay, good.
But we were discussing section 3, complaints by the public, page 5. And the discussion was around the perjury statement. Should it be in the complaint form? But also then I think we were discussing whether actually this discussion should even be part of the complaint, investigations procedure, or it should actually be part of the complaint procedure and fleshed out there. But either way, there were some follow-up things that I needed to do to update you on the discussion. So I did send an email and I did some research. I think I located roughly, I don't want to lie, but I looked into a certain number of law enforcement agencies in California and their oversight agencies, and I looked at their complaint procedure, complaint forms. And it doesn't look like any of them have the verbatim perjury statement included in the complaint forms. Although some reference the penal code section in kind of the general terms that if you provide wrong information, you can be, that could be a felony. And then I also checked with IA during one of our meetings a couple weeks ago whether it's mandatory to have that perjury statement. And although it's part of their complaint form, it doesn't look like it's actually required for them to initiate an investigation, and they'll do it on a case-by-case basis. So they'll do their best to get that perjury statement signed from complainants, but if they don't have it signed, but if they have enough information to move forward with the investigation, they will still do that. And the quote was that it's not a requirement. Mm-hmm. So here's the information I found for you. So let me know if A, we want this to be in this investigations procedure, or they're actually more applicable for complaints, and B, if we want it to be here, whether we want to strike that piece on the requirement to have the perjury statement, and something along the lines of we can require parties to sign any sort of documents.
Well, the last part about signing documents?
Just a general term, how I phrased it here, the commission may also establish forms that will require a signature, but not referencing the perjury statement in particular.
I'm sorry, go ahead, Doug.
Well, I was going to say, I think we can put, the information about the form in a separate complaint policy.
That makes sense. Do you think we should still reference at least this piece that in order for the commission to open an investigation, a complaint may be presented as afforded by law, and how the complaint can be submitted, and that SDPD should forward the complaints within 5 days?
Yes. Yeah, so I think that's what we decided last time, was we were going to keep that first paragraph and the last paragraph, and then you were going to research what you just reported on. Mm-hmm. We were going to include that in the complaint policy rather than this policy.
Okay, yep. So then, oh, I'm sorry. Was somebody going to say something?
No, I was going to say I concur, but my cough is back. Don't ask me why. It was gone, and now it, for some reason, decided to come back.
Okay, so how about this one? shall include complaints received from any person without regard to age, citizenship. Are we keeping this?
Yeah, I think so. There's no reason not to.
Okay, this too. And then anything that has to do with what sort of forms or documents the commission may require complainants to sign, that will be removed and be part of the complaints procedure, right?
Right.
Okay, so I'm just gonna make it in the suggestion mode. So I will be removing this for our discussion. Oh. Why is it not suggesting? It removes the entire sentence, so I'm just gonna strike through it. Okay. And this one. And this provision, should it be in this procedure about SDPD needing to forward us complaints within 5 days, or you also think it's more appropriate for the complaint procedure?
I think it actually should be in both, but I think it is important to have in this one.
Okay. I'm fine with that. So I think that was it. Those were the things that we kind of needed to clarify on this piece. The next section was cooperation between the commission, the police department, and other city departments. Kind of like general guidelines or that, recommendations. I don't think there are any questions or comments on this piece, except for, as I was rereading this, I felt like this paragraph, I felt like removing this paragraph, so let me know whether you agree or disagree in this one.
Yeah, it seems duplicative. It seems like it's a copy of the previous paragraph in much of the
Kind of.
verbiage. Yeah.
Yeah, I'm okay with taking it out.
Me too.
Okay, so I will add a note that, oh, I don't know what is happening today. I cannot work with the Google document.
Are you in edit mode or comment mode? You wanted to be in comment mode, right? Suggesting mode? Are you in suggesting
Okay.
mode or are you in
Yeah.
edit mode?
I'm in a suggestion mode. Okay, so agreed to delete this. Okay, so as we were discussing based about the approach on reviewing this procedure, we were going to read everything prior to the meeting, and because if there are any further notes or questions on this section, can we move on to the next one, or there are other things that you all wanted to discuss about this one or had any questions or comments?
I think the only things that I wanted to discuss, I made notes of, and well, a couple of them are just minor things like referencing the actual municipal code section when you talk about the implementation ordinance, and referring to the police department standing orders, policies and procedures, and I forget the third category, but you didn't include the policies and procedures in your list, and that's the one that we use the most.
Oh, here in the first paragraph?
Where you guys at?
Yeah, what paragraph are we talking about?
Why don't you do a find and type in general orders?
What was the word? I'm sorry?
General orders.
General orders?
I think that was the term that you used.
General provisions.
No, general orders.
General orders.
There you are.
Oh, okay. So I think this is in the next section.
Okay, yeah. Oh, I'm just gonna say the only things that I saw were a couple of terminology things.
Okay.
And then you asked a question in one of your notes on the investigative hearings. whether they were even necessary.
Oh, I'm sorry, Doug. Sorry for the confusion. So I was talking just for this, specifically on this
Oh,
section.
that section, okay, no.
Yes, cooperation between the commission, the police department, and
Okay,
other.
I'm sorry, I thought you were talking about in general, so no.
Yeah, okay. Commissioner Honoré, did you have any notes on your end on this one?
No, ma'am.
Okay, so I think we're good with the wording of this one then. So investigation guidelines, so a set of general provisions for investigations. Again, not necessarily like limited, but just kind of to set the guidelines. I think Commissioner Honoré had a question in provision M
Right.
on what actually guides when the complaint can be reopened, and there was a response on my end that this is directly from POBAR. And all of these criteria of when and why, or how, no, not when and under which conditions a complaint can be reopened, they're both from POBAR, so
Okay.
that
Yep,
was.
and you can see I was okay with that.
Yeah, and then there was a note that I said on whether the committee is comfortable with the suggested approach on reopening a case. So I included a request to reopen a case must be submitted in writing to the commission. The executive director and or chief investigator will make a determination as to whether to reopen the case and notify the submitting party in writing. So let me know your thoughts on this approach, if you want to modify it. How does it look for you?
Looks good to me.
Yeah, my only question is always, that the commission would have some, and I think we might have discussed this last time, that the commission will also know when this happens, right? That it won't just come to the executive director, chief investigator, they say, no, we're not going to reopen it, and then the commission doesn't know that that happened. The commission will always be advised when that takes place, right?
I think we can include something like that. I wonder how.
Well, and we'll notify the commission. Maybe just add and we'll notify the commission.
Yeah, I mean, it can just be, either reported out by the chief investigator or reported out by the executive director that this request was put into, it just be part of the report. But I think it's important that the commission itself at least know that someone made an attempt to reopen a case. Because the commission, they might have already spoken to a commissioner, and the commission may have recommended it. And so we at least should know that that a request was submitted and how it was disposed of.
I think this is definitely fine. So I just added and will notify the commission.
That works for me.
I didn't have any other notes or questions on this section. Did you have any comments or concerns or questions for this one? Investigation guidelines, general provisions.
I don't think so, unless there is a
general provision. No.
I put a comment off to the side if anything I had a question about, and there wasn't.
Yeah, I don't think there is anything here in this one.
Correct.
Okay. So the next one was guidelines related to type 1 investigations. So this is the section that I noted would merit a thorough discussion, but maybe not. So just a little bit of a background, again, that there was this countywide MOU implemented among all, if not all, but most police departments within San Diego County, where different agencies would investigate officer involved shooting cases, and particularly if there is an officer involved shooting case involving SDPD officer, then the county sheriff department would investigate it. So I thought this would complicate the way we approach the procedure, but I think I found a way to phrase it in a way that would still establish some guidelines between the San Diego Police Department and the Commission of Police Practices, and may not necessarily I guess it didn't turn out that complicated as I thought, but
Yeah,
let
well,
me know
y-
if
yeah,
you
well,
have any
I thought the way we
comments on
handled it was
this one.
fine because it doesn't mention the sheriff's department directly. But you do talk about the liaison providing that access. I'm just wondering whether or not we should reference the MOU in this document somewhere.
So I thank you for bringing that up. Two things. I spoke with Mr. Bennett on this, and his recommendation was actually not to reference the MOU at all.
Okay.
Because I'm gonna try to remember his position, and I think I may have included an email, and if not, maybe it was just a phone conversation between him and I. But his position is that the ordinance governs basically the relationship between the commission and the police department. It has nothing to do, MOU has nothing to do with the ordinance with us, but at that point. So we should just stick to, and it's gonna go through meet and confer with the San Diego Police Department. So we should just stick with working with them, and it's ultimately their responsibility to provide access and documents to the commission, regardless of any other MOUs they have with any other departments. So that was Mr. Bennett's recommendation.
So then in with respect to that, have you or Mr. Bennett read the actual MOU? First question. Okay, and so
Yes.
second question would be, or assumption, maybe in the form of a question, is that you did not find anything in the MOU that would allow the police department to legitimately inhibit our efforts to conduct our own investigation.
So couple of things there. I actually uploaded the MOU to our committee folder. So if you have any free time, you can definitely review it. It's not long. So the MOU, the basic kind of principle is that because the sheriff's is responsible for investigating the shooting cases, they will be the primary agency who does this, and they will be supplying all documents and access to the scene to the police department through the homicide unit. IA will not be part of that, but they will have access to the scene. So, I mean, it's just kind of different agencies, which definitely complicates the process, but
they've
for
got to give
our
everything.
purpose,
Sheriffs have to give everything to the city SDPD anyway. So that should. So in other words, that really shouldn't be an issue.
yeah, I mean, for our purposes, we are still asking SDPD, not asking, we are writing the guidelines for them to cooperate with us. How they do this, it's gonna be like on them.
Right, I got you.
And what I asked the PD after they, signed the MOU, because we didn't know about the MOU until there was a press release saying this has been signed. And we did have some discussions with the chief actually afterwards. And I asked the question of why isn't there a reference to cooperation with the CPP in the MOU, and the response was this is a general MOU that applies to all of the law enforcement agencies within the county of San Diego, and they didn't want to include things that were agency specific, like because not every agency has a separate oversight body that has the ability to do investigations. So that was I still think they could have done it, but they didn't, and that was their explanation.
And where's the MOU?
It's
Which
in
folder?
our committee folder in let me tell you right now. Committee folder, investigations procedure, MOU. It's the second document from the tab. It's called ATTJ Countywide Protocol for Investigations and Review of Officer Involved Shootings.
Gotcha.
But I mean, in practice, it will happen like this. Then let's say sheriff's department responds to the scene of a shooting. They will allow access to SDPD homicide unit and to people from IA. And then we on our end wrote a provision here, or I suggest to write a provision that we will be notified by the department as well. And the idea is that IA will request the sheriff's department to also allow our investigators access on the scene per this MOU. That's something that they would have to work out.
Okay, I'm good with it all.
Yeah, I like the way you did that.
And then I'm grateful for Paul Parker from CLERP who shared their MOU with the sheriff's department. So some of these guidelines are from there. I think Commissioner Honoré had one question here about a sentence: the commission investigators will not make any photo, audio, or video recordings while in or around the scene. And the note is that sounds like a curtailment, investigative independence. While this is true, I don't think in practice the investigators will be allowed to take any photos of the crime scene. Correct me if I'm wrong, but I don't think that would be like just allowed for anybody who's not an investigator involved in directly investigating the criminal case.
Okay, I think I understand that.
Doug, do you have any thoughts on this? I just figured that would just not be allowed, and I kind of wrote it in to let the, the DPD and the union up front that the investigators won't try to meddle or to be too nosy on the scene to hopefully alleviate any of the concerns that they may have. So that kind of was also a purpose for this.
Yeah, I was thinking the same thing of why is this in there? And I think the degree to which we include things like that will make it easier to get some of these things to slide through the meet and confer.
Yeah. And if it's sometime in the future, it seems to be an issue, we can always revisit it. Well,
no,
probably somebody else will be around to revisit.
Yeah, but in terms of whether or not what happens in practice in other jurisdictions, I don't know. You probably have a better sense than I do of whether or not they allow those types of photos and recordings at the actual scene itself.
I cannot imagine that for any, I would imagine only the entity doing the criminal investigation can take pictures and video recordings of the scene itself.
Okay, well, you're the professional. So
I mean, I'm not that professional in this in this particular aspect, but
why you have more experience than I do in terms of how that would be done. So
yeah.
And while I'm willing to compromise on that, the question of, again, investigative independence. These are trained. We are sitting in trained investigators. Right. So it's not like they don't know what they're supposed to do or what's supposed to happen on a crime scene, and they're supposed to be independent. In terms of future thoughts about transparency and trust, the critical question coming from, and I'll say this again, I said before, I'm on this commission because somebody in the community thought that I might be speaking for the community while I'm on the commission. As such, my concern is that the community will be thinking, what is it that the police department doesn't want our trained investigator to see or record that they didn't receive or record, right? And that's the bottom line here, right? Is our channel. The reason we exist is because although we think we have a great police department, we know that there's room for improvement, and we have seen some things that have caused us concern. And transparency and trust is what the commission is supposed to help create with the police department. And again, it becomes the question: what could our investigators see or record that the police department didn't want the public to see or record? And the investigators know what the law is. They know what can and can't be shared. They can know what does and doesn't qualify as valuable evidence. So, again, I understand the compromise that's needed for the CPOA, but at the same time, the question still remains: this is an investigator who the ordinance says we have our independent investigator for the purpose of making sure that we can look for maybe things that the police department overlooked. And now we're saying that when the that investigator is on the scene, that investigator cannot record what it is that investigator may have seen that the police department may or may not have included in their own investigation. So it's kind of stands as a contradiction to the intent of the ordinance. But I do again understand why this compromise needs to be in here.
I mean, I think you're making a great point, and now that you're saying it, again, in practice, I don't know how this will play out, because ultimately the sheriff's departments are the custodians of the scene, right? So whether the investigators will be allowed to take a photo or not, that I think that would play out in practice, but you know, maybe not to limit ourselves. I'm just thinking now about what you shared. Maybe we can rephrase it to say the commission will not. It already, like the previous sentence already says, the investigators will not seek access to areas that may obstruct criminal investigation, and maybe adding that the commission investigators will not engage in any actions to obstruct criminal investigation, and let the issue on taking photos, videos, and audios play out in practice instead of explicitly saying that. I can make that suggestion.
I like that.
Yeah, and I'm okay with that too. Let me ask a related question. What about interviews with witnesses who may still be on the scene?
Oh, yeah.
So the investigators, I think, have full right to canvass the area for any witnesses, video, and take down people's contact information. The investigators have full right, and I don't think they conform to any, like, there are any limitations to what investigators can do.
Okay, I just want to make sure that wouldn't preclude that. Well, I'm okay with taking that out. And this is the kind of thing that may come up in a meet and confer.
Yeah.
And I think I probably would change my mind from what I previously said. Maybe wait for them to bring it up. If they bring it up, we would include it. If they don't bring it up, we wouldn't include it.
Yeah.
Okay.
I'll just paraphrase it to more general. General phrase about not obstructing criminal investigation. Obstructing investigation, and remove reference to photo and audio. And also, we can also potentially make an addition. I'm thinking about it here, in this third paragraph. Sorry, where is this? In this paragraph, the police department will provide all relevant evidence and documentation to the commission as soon as it becomes available. We can even specify including lists of any potential witnesses. Just to make an addition. I don't know if you want to make that, because Doug, you mentioned witnesses.
Yeah, but that would be part of the. That would be.
I mean, yeah, that would be part of. That's why all of that would be part of the case file. But again, it is investigators' independent job when they're doing an investigation to find out who are witnesses to the incident, not only from, and that can be done for multiple ways, right? By like interviewing people, and they will be naming other people by looking at video, documents, etc. So there are many ways how an investigator can identify witnesses themselves, and nobody has any limitations on that.
So it sounds like your argument is there's really no need to put it in this section.
Yeah.
Yeah, I would agree with that.
Okay. Any other, I mean, this is an important section, so any other comments or questions or edits you had for this one?
That's all I had, right? Yeah.
Done?
No,
No? Okay,
I thought it
so,
looked good.
okay, great. So the next section was still within the general guidelines, but it's about interviews. So, this is kind of the general provisions on the interviews, and I proposed some appendices for scripts, for complainant, civilian interviews, and then for officer interviews.
Mhm.
And then I had a note whether we want to include all of these guidelines from POBAR on how to interview officers.
You know, it doesn't hurt. Again, it shows the POA that we are respecting POBAR if we quote POBAR. And so,
Mhm. Okay.
I mean, it may not be necessary, but I don't think it hurts.
I like that thinking.
That is fine
That's
by me.
Good politics. Maybe you should apply for that executive director position that has to be
No.
politically savvy.
I mean, I would say it's default that we all know, the POBAR and the provisions. So I think it should be assumed that everything we do is in compliance with POBAR, but I do see the argument for including this here.
Yeah, we want to make them feel good.
Okay, and then did you want to review okay, let's talk about this one. I think Commissioner Honoré had a question on how is it determined when an officer needs to be read their Miranda rights? And I responded that that can happen at any time. That may be apparent prior to the interview, or that may be apparent during the interview. And the idea is that the investigator will go in the interview already prepared and anticipate if there would be an instance that they need to read the Miranda rights. And it looks like Commissioner Honoré was fine with that comment.
Okay, let me ask you a question about that though.
Yeah.
That's, I understand why that's in there from the PD's perspective, but the commission doesn't charge anybody with a crime. And so would the commission need to read somebody their Miranda rights? Because the Miranda rights are read to somebody when they are being
Charged.
arrested.
Yeah,
I
so
mean-
I think it's not necessarily, so if you're, let me go to the script for the officer.
This is
Interview,
all POBAR stuff, right?
yeah, that's the requirement from POBAR.
Yeah, so I think, again, in terms of politics, it's probably wise to just
Yeah, but-
leave it in there and let them know we're going to do things according to their procedures.
But
So
I guess
basically,
I'm asking the question is that I guess I don't understand why we would give a Miranda waiver, because a Miranda waiver is given when you are planning to arrest somebody for a crime, so they know what their rights are. And we're not going, but we don't have the ability to arrest anybody. So why do we need to give a Miranda waiver? It's just a question. I don't know.
well, I mean, that's a good question.
Hey, that's a
And
good point.
frankly, because that was included originally by Mr. Bennett, and from our conversations with him, it was my understanding that we also have to read the Miranda rights. But the way it's written in the script, it's to inform them, the purpose is to inform them of their constitutional rights, because they are not stripped of their constitutional rights, even if we are interviewing them. So that would be the purpose. As soon as we know that that could become part of the criminal investigation, I feel like we have to advise them of their constitutional rights regardless. So that's why my understanding it's in here. But I can double check with Mr. Bennett whether we even have to do it.
So why don't you do that? If for no other reason than curiosity, because I don't quite understand why we would have to, but I understand. Well, I guess I'd like to confirm that.
Sure.
I mean,
I did draft this script, and Mr. Bennett reviewed it. for all like the legal references, because the main things you have to advise the officers is that they are part of the administrative investigation, that they don't have the right to refuse to provide testimony, that they can be subject to insubordination penalties and termination if they don't provide testimony in an administrative investigation, that anything they say in an administrative investigation cannot be used in the criminal investigation.
Right.
And then those are like the by law that they have to be advised. And then my understanding was again that if there's any circumstance where they can be charged with a criminal offense, that they have to be advised of their constitutional rights, but not in a phrase or in a form that a police officer would inform a person who they're arresting, but in a different form, which is here. Do you understand the rights that I explained to you? With these rights in mind, do you still wish to speak with me about this matter? Because they can say no and technically invoke their constitutional right, and we cannot do anything about that.
Unless we want to issue a subpoena.
So I'll
You can
double
issue a
check.
subpoena, but you still can't make them talk.
Well, that's
Yeah.
true. Yeah, but the penalties are different between not cooperating because they choose not to under this circumstance and not cooperating because they choose not to under a subpoena.
So if they refuse to cooperate, we can still try to force them to testify via subpoena because it's an administrative investigation. Yeah.
So where are we? Did we decide we want to keep it or we're gonna ask Mr. Bennett?
Yeah.
Okay.
Well, the first part definitely has to stay, the Garrity Lieberger
Right.
admonishment.
Oh yeah, yeah, absolutely.
That has to stay, but just I will confirm whether the Miranda portion needs to stay here or not. And then in terms of the complainants script, this is just kind of a basic script that I came up with for the interview, relying on examples from New York City that we were using. The script reads that the person needs to sign a verification statement, which was a requirement in New York State. Because we discussed that it's still up in the air whether complainants will be required to sign perjury statements, I would suggest removing these references about signing any sort of documents in the interview.
This one's okay. That's for complainants.
What was that, Commissioner Honoré?
The one we're referencing right now is for complainants, right? Not the
Yes.
officer. Okay. That is Appendix A. Is that where we are? Yeah, here we are. Okay. Okay,
But it's different to have somebody sign a verification statement at the conclusion of the interview to verify that all their statements are true, than having them, sign a perjury form when they make their complaint.
Yeah, and the reason why I included it here in this iteration, because this is how it was in New York City, and we were discussing whether they will be required to sign a perjury statement. If they will be required to sign a perjury statement, I think that would be the only piece, because the verification statement would be redundant.
Right.
So because we kind of haven't finalized what is it the complainant would be required to sign during the interview or during the investigation, I think the question is, does any sort of reference about signing documents should be part of the script, or it does not necessarily need to be part of the script, and we'll figure out that piece once we draft the complaint procedures.
Well, this is part of the
Yeah.
investigation procedures, though, not the complaint procedures. And so
That's right.
I would keep it in there. And I think it's a good investigatory practice to have the people you're interviewing verify that either one of two things, either have them sign a statement like this or have a summary of, like what I've seen done is that they're provided with a summary of their testimony and they sign the statement of their the summary of the investigator's summary of their testimony, saying that this is accurate. And I think that's good for two things. Number one, to make sure that the person understands that they are expected to tell the truth, but it also, well, in terms of the summary, it makes sure that the investigator has accurately understood what they were trying to convey.
So I'm okay with keeping the verification form, but not necessarily the summary piece, because during the interview, the investigator will not have a summary. And this
Okay.
is more at the end of the interview.
Yeah, and I wasn't suggesting we do that. I was just saying that that's a practice I've seen in other places.
Got it, got it. I would just suggest if we want any sort of written verification statement, it would be just something along the lines, I confirm that all I said is true to my knowledge,
Okay.
something like that.
But then the question becomes, when do we inform the complainant that this is required?
I think it says in the beginning. You're
'Cause
being.
this is the admonition that we're talking about right now, right?
Yeah,
So
file,
not gonna
please
tell
be
them
advised,
that.
it says in the beginning, prior to the interview, that you will be asked to sign the verification statement. That's
Right.
advisement prior to the interview, and then at the conclusion of the interview, I'm now presenting you this verification form for signature. So yes, they will be advised of that prior to the interview.
And so we're keeping these statements, is what you're saying.
I
So I thought the discussion was on whether we should or should not keep those statements.
Yeah, my discussion was about the perjury statement, because I thought if we will be requiring them to sign the perjury statement, that this may not be necessary, because the perjury statement kind of
Gotcha.
serves this
Okay.
purpose already.
Okay, right.
But from what I'm understanding, it's unlikely we will be requiring the perjury statement.
Right. Okay.
Well, and either effect, it doesn't hurt to reinforce it.
Yeah.
And
And that's a more general and lighter form than an intimidating perjury statement, because it's more of a to kind of affirm that the person is saying is true to the best of their knowledge.
And then some of the documents, I did not look at all of them, but I did look at a few of them, do state the law that, you have to be truthful in your presentation. If I remember correctly, right? Some of the complaint forms from the other agencies indicated that, or stated on the complaint form, here's a law that says you have to be truthful, and you can't be, well, you have to be truthful, you can't lie. Did I not see that on some of those? I think I did.
I think so, yeah, but I
Yeah.
think we can modify the language of that form for sure. This script just kind of references that you will be asked to sign a verification statement, and what will be included in the language of that verification statement, that can be tweaked once we get to the complaint procedure. That's my thought
Right.
process.
Okay, so I'm good with that.
Doug, any thoughts on this?
yeah, I'm good with it too.
Okay, so I'm leaving this then.
Okay.
Edit. Reading this. Any other discussion portions on the admonitions?
I will confess that I didn't read them because they were boilerplate.
Sorry, say that again.
I will confess that I did not read the appendices because I thought they were boilerplate.
Oh, no.
And
So I did read them, and I still thought they were boilerplate. So, this is a good conversation.
Yeah, no, definitely. This is a modification of New York City 1, and this is most of my modification of Mr. Bennett's admonition.
Okay.
Yeah. So yeah, I think we have time, so definitely if you want to take another look at those and get back to them next meeting, I think that should be fine. Okay, so and that was part of the interview. Section, did you have any other notes? Because we went over my notes and questions for this one. Did you both have any other notes for the interviews piece?
Nope, not me.
No.
Okay. So the next one is investigation findings. So this one talks about general 6 categories of the finding that an investigator can come to after an investigation. So the ordinance specifies 4 findings, but the way it's worded, I don't see that it's limiting the commission to only those 4 findings. So I suggested adding additional findings that an investigator can come to after an investigation. So can be no finding if a complainant or impacted party failed to produce any information to further investigation, nobody could be reached for an interview, or refused to cooperate and provide any evidence, and referral or no jurisdiction. Any comments on this?
I think that's fine. That
Okay.
for some reason, the PD at one time had on their list of findings kind of the equivalent of the no finding. And I forget exactly how it was worded, but it was a complainant not cooperative or something like that. And they took it out because they didn't figure they needed it. But I think it makes sense, so we can then have a finding for each and every case, because it can be one of the 4 findings, or we're not able to make a finding for whatever reason, or we referred it elsewhere. So I think it makes sense to include those 2 other additional options, because then we're giving our annual reports. We can say we received 314 complaints, and 6 of them are no findings, and 7 of them were referrals to other agencies, or no jurisdiction.
In practice, I also don't think this will be used a lot, but I think it's good to have it because CPP has the discretion, right, what to investigate. So technically, when the case comes in, the commission may already make certain evaluations, like, is it likely that people will participate? Is it likely that investigators will get the evidence? And even decide at that point not to take the case. This is more applicable to other agencies, like, for example, in New York City, they don't have the option to discretionary decide what to investigate or not. They have to investigate everything that is filed within their jurisdiction. So these agencies will have more use for these findings for sure, and more numbers of complaints that will be closed as no finding or referral for no jurisdiction. But I think it's good to have these just in case.
You can still have a situation where either you have a third-party complaint, or the complainant makes a complaint and it's something that the commission says this is definitely something we want to independently investigate. And then when the investigator gets into it, the complainant is nowhere to be found, or whatever. And then so I think you need to have the ability to close the case without a finding.
Absolutely. Yeah, I think that's definitely good to have.
Oh, yeah.
And the next section is basically what the commission may do once the case is presented to them after the investigator does the investigation. And there are some options for the commission here, which most of them were Mr. Bennett's proposal, which I think are great. I did have a few suggestions on modifying these, but it's agree with investigator findings, disagree, refer complaint back for staff for investigation, defer further action, conduct a hearing, propose disciplinary action, or take any other appropriate action. I think that's a good point that doesn't limit the commission to these 6. One piece I wanted to discuss, though, is the summarily, I cannot pronounce this word.
You did fine.
Dismiss the complaint in whole or in part, and when it can be applicable. to do so, because some of the things that fall under this summarily dismissal can be resolved by no finding or referral. And frankly, I've never encountered this, so I'm just curious whether you think
I think that
it's a-
that came from the CLRB procedures. I think that that's
Mhm.
where that came from, because we copied parts of this from well, Mr. Bennett copied parts of it from CLRB.
Mhm.
But
Yeah.
it's something that we had suggested that he do, because we like, especially when it came to the investigative hearing. The investigative hearing procedures were modeled on what CLRB uses, although CLRB doesn't use that process very much. They have a very well-defined process. So anyway, what are you suggesting? Are you
Well,
suggesting
I was just curious to hear your thoughts on like whether this is a good option for commission, and if so, we can definitely keep, but I would remove some of the conditions when a complaint can be summarily dismissed, because some of it can be resolved by no finding or referral, no jurisdiction, and it wouldn't even need to go until a summary dismissal. For example, the commission does not have jurisdiction over the subject matter, right? That could be something an investigator can do as part of a referral and no jurisdiction disposition, or
yeah, so you're
lack
saying, yeah, so it's kind of duplicative, either you do one or the other.
lack of cooperation by the complainant. So that already will be part of the no finding. So I'm not opposed to summarily dismiss. I think it's a good option. I would just remove some of the things from this list of when the commission can summarily dismiss, and some of the things that fall under these two categories. So
Yeah,
I would remove this one
mhm.
and this. And I would leave the other criteria when the commission can summarily dismiss. So does that sound okay?
Yeah,
Yeah,
is
that
there a
makes
way
sense.
to parenthetically state a reference to the no finding?
Here?
Yeah, so when we're talking about the summary dismissal, can you parenthetically comment that this applies in situations other than the no finding situations?
But I guess,
I'll
What
scratch
would-
that. I don't think it's necessary, so scratch it.
yeah, I'm just like figuring out what would be, I think they're mutually exclusive.
Okay.
But I was curious to hear your thoughts on this one. The commission is able to summarily dismiss a complaint that is frivolous or clearly devoid of merit.
I'm sorry, I thought we were going to talk about 4, because I want to talk about 4, but we can talk about 5 and then 4.
Oh, okay.
Why can't we do an investigation if they're no longer employed by the? And I think I asked, yeah. Oh, did you? You gave me an answer to my question, or did you?
I did say that we can.
Okay, then why do we need to have that then? I think maybe we should take that out.
Yeah, I would say too. I just realized why you asked this question. I was thinking more of the commission still can't do investigation, but maybe they'll look at the case and determine that there is no purpose in wasting resources if the officer left. Maybe it's like a less serious case. So I was thinking more of that in that circumstance.
Oh, I see what you're saying.
I mean, it can, like, again, I don't think that excludes this condition prevents the commission from investigating a case if the officer is no longer employed, if they want to.
I see what you're saying.
And there's nothing already in any ordinance or procedure or policy that would prohibit us from investigating a situation that occurred for an officer who has left the force.
Okay, but
No.
but can we word this in a way that that's clear? Because when I read it,
Mhm.
the conclusion I jumped to
Mm-hmm.
was that we're not allowed to,
I see.
and that's why we're summarily dismissing it. And can we
I think the
maybe say
language-
that the commission does not believe that a investigation is, or go back up to where it was, so is no longer employed, or so the subject offer is no longer employed by the department, and the commission does not believe that an investigation is warranted or is therefore warranted or
Mhm.
necessary.
No, this language already says summary dismissal may be appropriate in the following circumstances, and one of those circumstances is a subject officer is no longer employed by the department or
Yeah, but
in the interest of
I guess I
justice.
would just like to see it worded in a way that
Mhm.
a person would not come to the conclusion where you're summarily dismissing it. Determines.
I mean, I can propose,
I would just say that the investigation is not necessary.
and the commission determines the investigation is not necessary.
Or even not warranted.
Yeah. And how about in the interest of justice? What does that mean?
I'm gonna admit this is a copy and paste from Mr. Bennett's draft, so that sounded fancy and legal, so I
I mean,
left it there.
but what was it intended to
In the interest of justice.
to reference, so it's in reference to a subject officer. It's not like a separate category. So I think by saying that it determines that an investigation is not necessary is better than in the interest of justice. And so in the interest of justice could be a reason why the commission
Does not want the
yeah,
investigation.
or it could be that, they feel that it would, involve resources that aren't worth the time.
Mm-hmm.
If you're, but in some cases, I think it's absolutely essential that you have a investigation of an officer who who left the department, because you want to have it on record so that if they
Mhm.
seek a position in another department, we have it on record.
Absolutely. I mean, yeah, I thought it was a nice provision, but I get that it looks like it may be.
Well, see, but yeah, well, and so doing it the way he did there, I think is fine. So adding the words I suggested
Yeah.
and taking out are the interest of justice, which does two things. It answers my question, making it clear that it, it's only when they think it's not when it's necessary. And it includes in that in the interest of justice.
Mm-hmm. Okay. So I just wanted to flag that we are at 7:04, and there were a few other things that I think in this section that merit a discussion. So I propose that we resume this at the next meeting.
Okay.
How does that sound?
That sounds fine.
I will make a note that we will resume.
How much further do we have?
Let me see. Sorry, let me just make a note. Resume here. So I think we have to discuss this piece. Whether the complaint is frivolous, clearly devoid, etc. Let me see. And then the next section is notification of parties. Doesn't look like there are any comments there. And then the investigative hearings. I think there are a few comments and edits.
Mhm.
And that would be it. And then confirming with Mr. Bennett about the Miranda portion of the officer admonishment. So it looks like we went through the majority of it.
Okay.
Yeah, so I think if we approach the next meeting the way we approached today's meeting, we should be able to complete it in the next meeting.
Yep, I think so.
Okay.
All right.
I like how you're task oriented and keep us on task and on our time frames.
Yep, I mean,
You're a better chair than I am, but
Thank you, Doug. Any last minute notes or things we need to discuss?
No, I think we accomplished a lot today.
Okay, and our next committee meeting is in 2 weeks, right?
This is from today. 13th.
Yes, because we're not, it'll be the,
Ooh.
The week when the commission is not meeting.
and actually, hold on just one second. Let me, 'cause there was one time when I discovered I may have a conflict and I'm not sure which week that
Yeah,
was.
I have a conflict on that one. That's why
Ooh, I don't remember when it
have
was.
something that can-
And didn't we decide that we were, we only scheduled through March and we're going to decide after then?
I don't think so, but
Or maybe I'm mistaken. What does our calendar invite say?
our calendar and I'm sorry, calendar invite says operating procedure. It goes all the way through June.
Okay, then maybe I was confused with another meeting, but let me just look at my calendar anyway for the next couple of meetings.
Yeah,
Uh,
I have another meeting to be at 5 from 5 to 7 on the 13th.
What was that, Commissioner Honorary?
I have another event from 5 to 7 on the 13th.
Hmm.
Well, what time will you be home from that event?
I could probably be home by 7. It's downtown. It's a university club, so by 7:30 at the latest for sure. Because it's open.
Well, I would say maybe we could do 7:30.
You want to do that? That'll work. Yeah. Work for me, if that works for everybody.
Is that
else.
okay, Olga? I know this is beyond your working hours.
Oh, let me take a look in my calendar. March 16th. Just want to see if I have any personal commitments. 13th, right? Not 16th, 13th.
Yeah, 13th.
Oh, that should be fine.
Okay, and then the next one would be on the yeah, so the conflict was not with regard to this committee, so
Okay.
perfect.
So
Then-
March 13, I will ask Alina to update the invite to 7:30.
Okay.
Okay, and then Doug, I don't know if you have a few minutes to stick around after we conclude this meeting. I had a quick question for you about something different.
Okay, that's fine.
All right. Well, it's your call. We end the meeting.
Okay, I adjourn the meeting.
Okay.
Seeing no opposition, the meeting is adjourned.
No
opposition here.
opposition.
All
Okay.
right, ladies and gents.